May I please? Malad, at the very outset, Malad, I am extremely sorry, Malad, for my inconvenience today. Malad, item number 4 and 11.
These are 2018 matters.
Yes, 18 matters, Malad. Today, Malad, I have extremely Malad inconvenience, Malad. Can it be taken after Malad the vacation, Malad? Any convenience day, Malad?
Unless circulate a note in advance.
Malad, that
It's
is
very difficult to,
yes.
because we are listing two matters on Tuesdays and Thursdays. So
For that all, I am extremely sorry, Malad.
Transferring winter vacation is paid for by land transfer notification.
Item 4 and 11. Item 4 and 11.
4 and 11.
Development.
May I please also? I have a prayer in respect of item number 1.
Item 1.
Item 1.
This was a fixed matter.
It's a fixed matter. Yesterday, I have a adjournment. I have moved, but the other side I could not take the consent. They have not. They have some objection.
No, because
Malad,
criminal petition.
That's true. That's true.
Adjourn.
Yes,
Malad,
this is that.
My difficulty is, Malad, I'm led by the learned AG, Malad. Because of some sudden engagement, Malad, he is out of station. Malad, I prefer taking up the matter on third or
we would like to protest very strongly because this is the 4th time, and every time it's getting adjourned because of some reason or the other. And we finished argument. Advocate General also finished, and now he's delaying the matter again and again. We don't protest otherwise, but here we must protest. We feel that he's not taking the matter seriously.
Or if the petitioner sides argues the matter.
No, because we don't know. You see, the difficulty is that the bench is not. We are not sure about the bench.
That is one aspect.
We are sure about today, not about tomorrow.
I have the alternatively, Malad, if the petitioner sides argues, Malad, then kindly allow us to make my senior submission on 2020.
We can't. You see, it
No,
has
that comes to the same thing. I'll finish in half an hour. We continue. I'll finish in half an hour.
The problem is that you see the bench, we are not sure. We can't hear a matter and then have it adjourned. Last time it happened.
That's true.
So we will have to, whenever we start, we'll have to end it in the same week.
Same day I'll finish for half an hour. For me, don't give me more than 25 minutes. No more than 20.
In that case, Malad, kindly accommodate us till 20th, Malad. My senior, he has instructed me to pray for 20th, Malad.
On
20th, Malad.
20. Because there will be motion day. There will not be a hearing day.
Right.
Otherwise, 19 is okay, Malad. 19, if it suits your lordship.
19.
No, because those will be not non-hearing day. Just before the vacation, we have
Yes,
only motion day.
Your lordship, any date, as per your lordship's convenience.
The third would have been better, but even Malad, my senior has instructed me that on 20th, Malad, he will be in a position to argue, Malad.
See, we are fixing a date, but on that date, if you can't argue, you submit your written submissions. We'll have to end this matter. If physical argument can't be done, do it by video conferencing, do it by written argument. But it has to close on the next day.
Grateful, Manoj. Very grateful.
Mr. D. Nath, learned additional senior government, senior government advocate has prayed for adjournment on the ground that the learned advocate general is out of station. Full stop. Mr. Colin Gonzalez, learned counsel for the petition, senior counsel for the petitioner, assisted by Ms. D. Ghosh, learned counsel. Senior advocate, assisted by Ms. D. Ghosh, counsel for the petitioner, raises strong objection on the adjournment. As earlier also the matter was adjourned on several occasions. Next, the learned senior government advocate has submitted that the learned AG is out of station. What is the prayer for adjournment is made? Next para. The matter is being reluctantly adjourned. So it is made clear that if that on the next date of listing, if arguments cannot be addressed physically, the both sides will have liberty to make their submissions through video conferencing mode or by submitting a written note of argument. First, it is made clear that no adjournment would be granted on the next date of listing under any circumstances. Next para, list on 7 January 2025. So we are giving you all three options:
Malay.
physical argument or
I'm highly obliged.
by
Grateful.
virtual mode,
We'll do that.
video conference through written notes.
Lord, I'm obliged.
Because our difficulty is that a bench is not certain.
Yes, yes.
Lord, I'm obliged.
Yes.
Item number 5, my lord. Will be taken next week, my lord, or
You see, we are listing so less matters. If you don't want to
Yes.
do,
today, my lord, I am not having the file, my lord.
it's very unfortunate.
After vacation, my lord.
Very unfortunate.
Yes, please.
You could have, if you don't have the file, you could have told us yesterday. What's the great difficulty in addressing us and telling us in advance
Yes.
by
Sorry, my lord.
not being circulated?
Sorry for that.
No, you inform your, you give a notice to your petitioner. If you're taking an adjournment in Tuesdays and Thursdays, you give a notice to your
Next. After vacation, my lord.
parties. Both sides are represented. As Mr. S. Islam, let me counsel for the petitioner prays for adjournment of the matter. This matter is of the year 2018. So accordingly, the learned counsel for the petitioner shall send a written notice to the petitioner informing about the adjournment taken at his instance. First of all, proof of service of such notice will be produced on the next date of listing. Next list after ensuing winter vacation. Notice has to be given to the petitioner. 5. Yes.
May please your lordship. Lordship, if it is not inconvenient, lordship, can this item number 16 be take up before rising your lordship at least? I'd like to place some few facts, lordship.
15.
16, lordship.
Oh, 16.
Yes, lordship. The matter pertains to lordship tender and the in that area, lordship, the Karimganj, it falls under the Karimganj district. Since been years, lordship, the people are suffering as well as the other financial implications upon my appellant.
Okay, we'll try to
Yes, lordship. We'll
try
try,
to-
lordship. Much obliged.
inform the other side.
Yes, lordship.
May I please your lordship?
Yes.
My lord, on last Wednesday, my lord, I made a prayer for listing of an IA, my lord. As it is not listed, my lord, I made an inquiry with the registry, my lord. Registry, my lord, told me that the matter is, my file is lying with Mr. Justice Emma Pathak. Actually, my lord, the matter was heard, my lord, on
Then you'll have to move the registry. We can't, because if we know that the file is with another honorable judge, we can't call it.
since 4/11/2022.
But still, we have our limitations.
Behind us,
You may move on the administrative side to the honorable chief justice, but we can't, I do not have the authority
my lord.
to call for a record from the chamber of another honorable judge.
My lord, my lord. I
You have
understand.
to move the
I
registry.
understand. I have another prayer, my lord. Item number 6 and 10, my lord. If your lordship allow me, I'm not feeling well today, my lord.
The 2018 matters, we are
My-
finding it very difficult to adjourn without an advance notice.
If lordship,
We are following a policy. If we are praying for an adjournment on Tuesdays and Thursday, you inform the client about the adjournment
Then
taken
my
at your
lord, okay, my
instance.
I'll do it on Monday.
Huh?
I'll do it on Monday.
Hmm.
Okay. 6 and 10.
If you are unwell, we'll upgrade and take it up.
Fine.
We'll take it up. Those are upgraded matters.
Item 2 for orders.
But I have filed my affidavit, it's at running page 56.
I have not filed my lord the reply because they have not touched upon the factual aspect of the case. Whatever it is there, it is all on the basis of the law, my lord. May it please your lordship. My lord, in this matter, detention order was passed on 14/5/2024. My lordship should find it at page 30. This detention order, it is dated 14/5/2024 and has been served upon the detainee on 24/5/2024. Then, my lord, the grounds of detention has been served, my lord, at page 31.
Just a moment.
Hello.
Page number?
Page 31, my lordship.
Yes,
It's the ground of detention. My.
yes.
So basically, my lord, the cases referred by the detaining authority, they have taken into consideration two numbers of cases, my lord.
Yes.
My lord, these grounds of detention, as per the respondents, my lord, it has been served on 28/5/2024.
Yes.
Two number of cases, my lord, emphasis has been put, my lord. I was earlier arrested for two numbers of cases. Page 33, my lord, it is stated, my lord.
No, you see this page 31
My lordship,
is a part of page 30.
page 30, my lord.
So it has to be served to you on 24th. It can't be
My lord,
28.
I'm submitting on the basis of the affidavit filed by the respondent. at
No, then
page
you are reading it
59.
wrong. they say that the grounds of detention was served on 24, but Hindi version was served on 28.
Translated.
My lord, relied upon documents including Hindi translated copies were provided to the petitioner on
On
28/5/2024.
So there is Hindi translation.
Including, my lord, relied upon documents, my lord. But anyways, my lord, I'll not, if. Because my lord, second para, page 59, they have specifically stated the answering.
No,
to the
because
part of-
normally these are attached together.
My lord,
I have hardly found a case where these are separately served.
in certain cases, my lord, grounds of detention has been not served upon the detinue and that became the, my lord, ground for
In my
setting
experience, I have
aside
not,
the detention order. my
in
lord.
my experience, I have not got it.
My lordships, my lordships. But anyways, my lord,
Huh.
grounds of detention, my lord, they have relied upon basically two number of cases, my lord.
Yes.
Page 33, my lord. Second para G, my lord. In one of the cases,
Both the cases are 21C,
my lordships,
8,
20B 2C, my lord,
8C, 21C and 29. The other case is
29,
8C, 20B.
21C, 21C, 29 and 20B 2C, my lord.
Okay.
So 33, my lord, so far as the bail part is concerned, my lord, section 37 that I'll come, my lord, on my lord, after placing on record the factual aspect, my lord. Page 33, they have at second, my lord, G, ground G, my lord.
Yes.
They have said, my lord, Pramod Yadav, you have filed a bail application before the Honorable Court of District and Session Judge, Amingao, Kamrup in this case, which was rejected by the Honorable Court on so-and-so. Subsequently, you filed another bail application number so-and-so before the Honorable Guwahati High Court, which is pending before the Honorable High Court as on date.
Yes.
Then, my lord, 1.2 E, my lord, second last paragraph.
Yes.
However, you got bail from the Honorable Court of Special Judge. Why? Tripura granted fight order dated so-and-so.
Yes.
So in one case, my lord, bail has been granted. In another case, bail petition was pending when this order of detention was made, my lord. But my submission would be slightly different because my case is, my lord, the rigors of section 37 was not taken into consideration.
Yes.
Page 36, my lord. These are the list of relied upon documents.
Yes.
One of the relied upon documents, my lord, this NCB Guwahati crime number 1/2023, my lord, serial number 9. Supplementary additional documents filed regarding certified CDR at CAF has not been provided to me, my lord. That is, others I have received. Upon receipt of this detention order,
Yes.
page 37 is my representation, my lords. I filed this representation on 13/6/2024.
What is the date?
13/6/2024. Page 47. seal and signature of assistant jailer, 13/6/2024, page 47. Below, my lord, yours faithfully, Pramod Yadav. Page 47, my lordship is nothing.
Yes.
Then, my lord, after submitting the representation, page 53, my lord. This is the first memorandum of rejection. This was issued by the detaining authority.
Page number?
Page 53. This memorandum was issued on 21/6/2024.
Yes.
Passed by the detaining authority, my lord, after 8 days of my representation. Then, my lord, page 55 is the memorandum of rejection passed by the central government, my lord.
Just a moment.
My lordship.
Page number?
55, my lordship.
Yes.
This memorandum was passed, my lord, by the central government. It was passed on 18/7/2024 after 35 days.
Yes.
In the meantime, my lord, the matter was referred to the Central Advisory Committee. And on the basis of the report of the Central Advisory Committee, my lord, Deputy Secretary confirms the detention order, my lord. My lordship will find it at page 54. Page 54 on 16/7/2024.
Yes.
So these are the sum and substances of the, my lord, chronological dates, my lord, when the communication was taken place between the detainee and the detaining authority, my lord. Now, the first detention order, if my lordship may again come to page 30 for a moment.
Yes.
So detention order was of, my lord, 14/5/2024.
Just.
Yes, sir.
Yes.
And yes, 77. And it was served upon me on 24/5/2024, my lord. That is on 10th day, my lord.
Yes.
So, my lord, it was issued on the strength of section 3 of the P10 DPS Act, my lord. So if I may take your lordships to the P10 DPS Act for a moment, section 3, my lords. I have supplied the copies of the judgments.
NDPS Act.
NDPS Act.
Yeah.
NDPS Act, Constitution of India, NDPS Act, list of books, sir.
Yes.
Lord, Section 3 of P10 Act, it stipulates the power to make orders detaining certain persons. May I read, my lord?
Yes.
The central government or a state government or any officer of the central government, not below the rank of a joint secretary to the government, to that government, specially empowered for the purpose of this section by that government, or any officer of a state government not below the rank of a secretary to that government, specially empowered for the purpose of this section by that government may, if satisfied, with respect to any person within bracket, including a foreigner, that with a view to preventing him from engaging in illicit traffic in narcotics, drugs, and psychotropic substances, it is necessary so to do, make an order directing that such person be detained. Now, my lord, subclause 3 is relevant for me, my lord. May I read, my lord?
Yes.
For the purpose of clause 5 of Article 22, Article 20 of the Constitution, the communication to a person detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, but ordinarily not later than 5 days, and in exceptional circumstances and for reasons to be recorded in writing not later than 15 days from the date of detention.
Yes.
So, my lord, this clause, my lord, it says that the detention order shall be served upon the detainee not beyond the period of 5 days, my lord, but in exceptional circumstances, my lord, that too not beyond the 15 days, my lord, by reasoning, by citing reasons, my lord, for the delay.
Yes.
But in my case, my lordship has already perused page 30, my lord. It has been served upon me, my lord, on 10th day, my lord, that is beyond 5 days. But, my lord, no reasons whatsoever has been cited as to why, my lord, it has been served upon me, my lord, after 10 days of time, my lord.
Yes.
And this section, my lord, it draws its powers from subclause 5 of Article 22 of the Constitution of India, my lord.
Yes.
That as soon as what has been specified in Article 22, subclause 5, my lord. Clause 5, may I read for a moment?
Yes.
Constitution. 22 subclause 5, my lord.
Yes.
When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the ground on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. So what shall has been used, my lord, and 3.1, my lord. Sorry, 3.3, my lord. The time frame has been specified. my lord.
Yes. Yes.
Then, my lord, that my contention, my lord, it has been answered at page 59 of the affidavit filed by the respondent instrumentalities, my lord. Page 59, second para, my lord.
59.
59 of their affidavit in objection.
Yes.
The answering deponent further begs to state that in the instant case, the detention order dated 14/5/2024 was executed on 25/4/2024. And the grounds of his detention and relied upon documents, including Hindi translated copies, were provided to the petitioner on 28/5/2024, my lord. This instruction I never received from my client, though, my lord, it has been relied upon by the respondent instrumentalities that the relied upon documents and the Hindi translated copies were served to me on 28/5/2024. So my case, my lord, I have pleaded that on 14/5/2024, the detention order was passed, my lord, and it was served only upon me after 10 days, my lord. But, my lord, nowhere in the affidavit, my lord, they have specified as to the, my lord, any reason that why they have not accorded any reason whatsoever for the delay caused, my lord, beyond 5 days, as to why, my lord, this detention order was not served upon me within the period of 5 days, my lord. No reasons whatsoever has been cited, my lord.
Okay.
My lord. My lord. My lord, the second point, my lord. After my representation was filed, my lord. Before that, my lord, while issuing this detention order, my lord, my another pleaded point is that, my lord, the rigors of section 37 was not taken into consideration, my lord. And that I have already placed, my lord, page 33, 2 aspects they have clarified. One of the case I was granted bail. Another case I'm yet to be, my lord, my bail petition on the date of filing of this case was pending, my lord, according to their, my lord, detention, grounds of detention. But, my lord, nowhere in the grounds of detention, my lord, it is their case that for the reason of passing of the detention order, they have taken note of the rigors of section 36 of the 37 of the NDPS Act, my lord. Simply, they have stated in the grounds of detention that one of my bail has been allowed in one case, another is still pending, my lord. But they are completely silent as to whether they have applied their mind with regard to the aspect that while issuing the detention order, the rigors of section 37 was taken into consideration by them, my lord. No, I have already given the copies of the judgments. I'll rely on that, my lord. But before that, my lord, only the technical aspects I am clarifying, my lordships. Only their reply, my lord. The reply also, my lord. My lordships. I have at para 14, my lord, page 14, I have specified with regard to, my lord, the section 37, my lord, issue. And they have at page 60, my lord, para 8 of the affidavit, my lord. It is their reply. Para 8, my lord. That with regard to the statement made in paragraph 14 of the writ petition, the answering respondent begs to state that detention order was passed by the concerned authority after thoroughly examining the available facts and circumstances, and on being satisfied that the petitioner was a habitual NDPS offender who continued to engage in committing NDPS offences even while being on bail. So that is the sum and substance of their reply, but nowhere they have put any emphasis or any reply has been.
Please come to the detention order.
My lordship.
What was the date of bail and what is the date of second arrest? Otherwise, if you
Sure.
have the dates,
My lord.
what was the date in which
Page
the
30.
bail was granted on the first case?
Page, my lord, 33, E, my lord. Second last parameter.
Just tell us the date.
29/2022. Special Judge, White Tripura granted bail.
29,
29/20/20,
209.
20/09/2022.
Yes.
And
And
my
the
lord,
second arrest?
second bail application pending as on the
No,
date
second
of-
arrest, date of second arrest.
Second arrest, my lord. So it is there. Arrested on 3/2/2023, my lord.
Yes.
That instruction I do not have whether after granting of bail by the honorable court below, my lord, whether he came out or he was, my lord,
No,
there,
if he does not come out, he can't be arrested in a second case.
my
A
lord,
person in jail
my lordship,
will not be arrested for a second subsequent offense.
subsequent, that is correct. my lord. So,
That's why.
my lordship is correct. So anyways, my lord. So their reply is only with regard to the bail part, but their reply is nowhere it is indicating that while passing the detention order, they had taken into consideration provision 37 of NDPS Act. Now, my lord, after that,
No, but tell me, I have a question. I always ask this question.
my lord,
You see, I'm not criticizing any particular judgment or any particular order
My lordship.
on PIT NDPS
My
cases. But please tell us, there's been a shift in the approach of the judicial pronouncement. At one point of time, it was that 37 is to be applied.
Taken,
Propose what you call
taken into consideration. my
has to be
rigors of
considered
section 37.
proprio vigore has to be applied.
My lordship,
Then came a subsequent shift, and it says that if the detention is too long,
Too long.
then section 37 does not apply,
Does not apply,
correct?
my lordships.
And then again, now there's a shift saying that 37 will still be applicable.
Still be applicable.
Now please tell us which person, except for the court taking up the bail matter, can really apply mind and say that 37 in this case would apply or would not apply. How would you, as a counsel,
My lordship,
be able to predict
my lordships.
as to whether the, what would be the possible view of the court on section 37?
37 itself, my lord. The NDPS Act.
No, I'll show you. I have 10 judgments from this court and other courts
Other courts,
where 37 was said to be not applicable.
not applicable.
Then,
So this is one of my,
no, I
Okay, my
understand,
lord.
but I'm just, this is a question
My-
I always have.
my lordships.
Section 37. Because when you are in this side paying for bail,
My lord.
then obviously 37 according to you does not apply.
So 37, my lord, number one, that honorable court has to come to a finding that he is innocent. And second, my lord,
He will not
if
repeat the
he is
offense.
released in bail, my lord,
Not be repeating the offense.
he will not repeat the offense, my lord.
So this
That is the basic crux of section 37, my lord. So now, my lord, so my lord, their reply that in one of the case he has been allowed bail, my lord. Then 37 would say, my lord, because in that particular case, definitely honorable court must have had came into a finding that he may not be involved in this particular offense. And if we release him on bail, he may not commit such kind of offenses in future. Number one. Number two, my lord, the other aspect, my lord, is, my lord, because under section 37, the learned PP would get sufficient, my lord, chance to object to the bail, my lord, before honorable court considers the bail application. And when the second subsequent bail application is pending, my lord. So that is where, my lord, the need for applying section 37 comes into play, my lord.
correct.
That is my humble submission. Then, my lord, after that, I filed my representation. And, my lord, my representation was considered, my lord, on, my lord, by the detaining authority after lapse of 8 days. And by the central government after the lapse of 35 days. Now, if I may take your lordships again to the memorandum of rejection at page 53. My lordship would see page 53, my lordships. It was, my lord, memorandum was issued simply citing that my representation has been rejected. But my case is, my lord, nowhere in this rejection, my lord, they have specified as to the reason, my lord, for the delay caused in considering my representation. Similarly, my lord, page 55,
Page number
Page 55, my lordship,
55. Okay.
my lordship.
Yes.
That is the memorandum of rejection issued by the central government. That is after 35 days, my lord.
Yes.
And in this particular rejection also, my lord, they have not cited any reasons whatsoever for the cause of delay in deciding my representation. Now, page 61 of their affidavit, my lord. Before that, my lord, my pleadings, my lord, I have specified at para 17, page 16, my lord. Page 17, para 17 and 18, my lord, para 17, page 16. May I read, my lord? Petition of extra state that the detention order dated 14/5/2024 was served upon him on 24/5/2024. That is after delay of 10 days. In the grounds of detention, it has been specified that the detainee can make representation to so-and-so, so-and-so, so-and-so. Now, my lord, accordingly, the petitioner filed his representation on 13/6/2024 before the appropriate forums. However, the petitioner's representation was rejected by the detaining authority only on 21/6/2024, that is after delay of 8 days. The central government rejected the representation of the petitioner on 18/7/2024, that is delay of 35 days. And my lord, page 61, they have given the reply, my lord, with regard to my paragraph number 17.
Yes.
May I read para 10, my lord?
Yes.
That with regard to the amendments made in paragraph number 17 and 18 of the writ petition, the answering respondent denies the same and begs to state that the detention of the detainee under PIT&DPS Act is within the purview of law, and as such, there is no violation of Article 22(5) of Constitution of India. Moreover, the petitioner's representation dated 13/6/2024 was also rejected by the competent authority via memorandum 21/6/2024 and 18/7/2024 by following due procedure of law. Again, the said detention order has been confirmed by the competent authority via order dated 16/7/2024. So normally, my lord, and other cases, my lord, I had also appeared in similar case in another case, my lord. There, my lord, in other cases, the respondent instrumentalities as they had tried to give certain explanations that for these reasons there was a certain delay in rejection of the representation filed by the detainee. But in this particular case, my lord, at para 10, my lord, which is a reply to my paragraph 17, my lord, they have those stated that it is as per in terms of law, my lord, but nowhere, my lord, in the entire affidavit, my lord, they have specified any reasons whatsoever, my lord, for the delay caused in rejection of my representation, my lord.
Yes.
So sum and substance, my lord, in with regard to the technicalities of this particular case, my lord, my issue, my lord, is number one, my lord, it has my detention order was passed, my lord, but served upon me after 10 days. Then, my lord, the rigors of section 37 was not taken into consideration. Certain documents, relied upon documents were not provided to me, my lord. And my lord, my representation was, there was a delay, my lord, considerable delay, which has not been explained by the detaining authority for, my lord, causing such delay in deciding my representation and rejecting the same, my lord. So now, my lord, I have placed certain citations, judgments. By some board. দুটা set বনাই দিছে দুটা set বনাই দিছে দিছে yeah প্ৰথম then one my lordship's judgment, my lord, 2021 4 GLT 584.
Yes.
Paonam Diana Devi versus Union of India, decided by my lordships only. Para 10, my lord. This is with regard to the section 37. May I read, my lord? The next point urged by the learned counsel for the petitioner is to the effect that from the detention order, it does not appear that the detaining authority has been informed regarding the provisions of section 37 of the NDPS Act 1985, which puts an embargo on power of the court to grant bail as a matter of course. In this regard, the learned counsel for the petitioner has placed reliance on the case of Devarasi Kashyap, para so and so, thereof is quoted below. That I'll place, my lord, subsequently at the time of placing of the judgment, my lord. Then my lordships divulge into the point of, my lord, delay. The delay part, my lord, is one of the crucial aspect in this particular case. At paragraph 11 of the said judgment, may I read, my lord? The other point urged by the learned counsel for the petitioner is inordinate delay in disposing of the representation. In the present case, the detainee had submitted her representation on 16/11/2020, which was served on the jail authorities on the same day. The superintendent of Central Jail Guwahati had forwarded the said representation to the Deputy Secretary to the Government of Assam Home and Political Department by forwarding letter dated 22/12/2020. The Deputy Secretary to the Government of Assam Home and Political Department had sent the representation dated 16/11/2020 of the detainee to the Deputy Secretary to the Government of India, Ministry of Finance, Department of Revenue, PIT NDPS, by forwarding letter dated 19/12/2020. In this regard, the learned CGC had submitted that the representation dated 16/11/2020 was received by the competent authority of the central government on 10/12/2020, and the said authority had disposed of the representation on 13/12/2020. In the case of Lala Paite, the division bench of this court had held that every day's delay is to be explained. In the case of Lipika Roy, the Supra, the division bench of this court had held that the detention order to be illegal as it took 7 days for the representation to traverse 295 kilometers from Dhubri to arrive at Secretariat at this court. In the case of Aslam Ahmed Jahira Ahmed Sheikh Supra, the detention order was interfered because it was left unattended for 7 days, for which it had reached the government 11 days after it had handed over to the jail superintendent, by holding that the delay had invalidated the order of detention as having infringed the mandate of Article 22(5) of the Constitution of India. The division bench of this court, while dealing with detention order passed under section 3(1) of the PIT NDPS Act 1988, had interfered with the detention order owing to delay of 31 days. And in this regard, reliance was placed on the case of Paira Singh versus State of Punjab AR 1987 Supreme Court 2377, where the Supreme Court of India had held that delay in dealing with the representation of the petitioner vitiates the detention order. In the case of para 12, my lord, in the case of Ajra Fatima, the Supreme Court of India had agreed that the High Court had given adequate and detailed reasons in holding that delay had been sufficiently explained in the counter affidavit filed by the respondents. However, in the present case in hand, no attempt has been made to explain the delay by the jail superintendent to send the representation dated 16/11/2020 of the detainee only on 20/12/2020. Similarly, no reason has been assigned why it took the respondent number 2 till time till 5/1/2021 to dispose of the representation of the detainee. Moreover, the Government of India has not filed any affidavit in opposition, and there is no explanation why the competent authority of the Government of India took time, my lord. In our case, it took time, my lord, but no explanation has been provided in the affidavit. Now 16, my lord, is finding of the honorable court.
That you may omit,
My lordship,
that you may omit.
my lordship. The,
You have taken note of that, you may omit that part, reading that part, because
only my lord, 16 EFG, my lord, last page. Hmm? Last page, my lord, EFG, E, my lord. The court is constrained to hold that the detaining authority had failed to make available to the detainee all the documents mentioned in the order of detention and in the grounds of detention, like the police report, including other documents based on which police report was made. Then F, my lord, the respondent number 2, who had disposed of the representation of the petitioner, had failed to explain any reasons for inordinate delay in disposing of the representation. This is important, my lord. Then, my lord, G, there is no mention in the detention order that the detaining authority, while passing the said order of detention, that it was aware of the rigors of provisions of section 37 of the NDPS Act, which prevented the courts from granting bail as a matter of course. So sum and substance, my lord, these three observations, my lord, it covers my case also, my lord. এরপরে কাজটা লালাপা একটু করলো। Then, my lord, another judgment, 1999 3 GLT 236.
this item we have already touched in the earlier judgment.
My lordship, my lord.
This will be
Yes,
repeated,
my lordship
repeated.
has taken note of it, my lord. Only, my lord, I wanted to show that every day's delay needs to be, my lord, addressed, my lord.
Repeating the essence of
My
the-
lordship. Then, my lord, 2021 4 GLT 574. 4 GLT. 4 GLT.
2020,
2021 4 GLT 574. Debarshi Kashyap, my lord.
this also we have dealt with in the earlier case.
Yes, my lord.
Any new point here?
Entire, my lord, citations that I have placed before lordship without wasting the valuable time of this honorable court, my lord. It touches, my lord, these are the basic crux of the matters, my lord. That delay, my lord, is a very vital point, my lord, which needs to be
Let me take
explained,
a note.
my lordship.
If any specific point you want to urge from this judgment,
My lordship,
you can do so.
my lordship. So that is the sum and substance of my argument, my lord.
There are 3 more judgments.
3 more judgments, my lord. 2021 5 GLT 703.
Yes.
Then, my lord, 1986 4 SCC.
This is also on delay.
Yes, my lord.
They're not required.
While issuing detention. Non-consideration of detainee released on bail while issuing detention order. 4 SCC 416. Then, my lord, only one with regard to, my lord, the constitutional validity, my lord. 2011 5 SCC. 244. Rekha versus State of Tamil Nadu.
Yes,
My lord, 2011 5 SCC 244.
yes.
Para
Correct.
13, my lord. 2011 5 SCC 244.
Yes,
Married, your lordship.
yes.
Para 13. In our opinion, Article 22 3B of the Constitution of India, which permits preventive detention, is only an exception to Article 21 of the Constitution. An exception is an exception and cannot ordinarily nullify the full force of the main rule, which is the right to liberty in Article 21 of the Constitution. Fundamental rights are meant for protecting the civil liberties of the people and not to put them in jail for a long period without recourse to a lawyer and without a trial. As observed in R versus Secretary of State for the Home Department, ex parte standoff, so and so, the imposition of what is in effect a substantial term of imprisonment by the exercise of executive direction without trial lies uneasily with ordinary concept of
Just,
the rule
just
of
a moment.
my lordship.
Okay. Mr. Thakur, we excuse you. We'll adjourn your matter. Item number, please tell the court master. Yes,
Para 13, my lordship.
13 we have read.
My lordship. Article 22, last para of article,
Mhm.
para 13, my lord. Article 22 hence cannot be read in isolation, but must be read as an exception to Article 21. An exception cannot apply only in rare and exceptional cases, and it cannot override the main rule. Then 14, my lord. Article 21 is the most important of the fundamental rights guaranteed by the Constitution of India. Liberty of a citizen is a most important right owned by our forefathers after long historical arduous struggles. Our founding fathers realized its value because they had seen during the freedom struggle civil liberties of our countrymen being trampled upon by foreigners. And that is why they were determined that the right to individual liberty would be placed on the highest pedestal along with the right to life as a basic right of the people of India. Right to liberty guaranteed by Article 21 implies that before a person is imprisoned, a trial must ordinarily be held, giving him full opportunity of hearing, and that too through a lawyer, because a layman would not be able to properly defend himself except through a lawyer. Para 29, my lordship. Only relevant paragraphs I'm placing before this honorable court. Married, my lord. Preventive detention is by nature repugnant to democratic ideas and an anathema to the rule of law. No such law exists in the USA and in England except during wartime. Since, however, Article 22 3B of the Constitution of India permits preventive detention, we cannot hold it illegal, but we must confine the powers of preventive detention within very narrow limits. Otherwise, we will be taking away the great right to liberty guaranteed by Article 21 of the Constitution of India, which was won after long, arduous historic struggle. It follows, therefore, that if the ordinary law of the land, Indian Penal Code and other penal statutes can deal with a situation, recourse to a preventive detention law will be illegal. Then para 30, my lord. Personal liberty protected under Article 31 is so sacrosanct and so high in the scale of constitutional values that it is the obligation of the detaining authority to show that the impugned detention meticulously accords with the procedure established by law. The stringency and concern of judicial vigilance that is needed was aptly described in the following words in Thomas Bassam Dale's case, so and so, my lord. So this is some in substance.
Yes.
So, my lord, in my case, my lord, at the very inception, my lord, section 3, subclause 3 has been violated. Because 3, my lord, it is very clear, my lord, that beyond 5 days, my lord, a detention order, my lord, cannot be, my lord, communicated. Outer limit has been given, my lord, 15 days. So, my lord, if it is beyond 5 days, but before 15 days, then, my lord, the reasons has to be recorded in writing. So plainly, my lord, if we see that beyond 15 days, my lord, the service of detention order itself would be illegal, my lord. It cannot be beyond 15 days. But my lord, after 5 days and before 15 days, it would be accepted, my lord, provided a reason has to be provided in writing, my lord. So at the very inception, my lord, before going into the other aspects of this particular case, section 3, subclause 3 of the PIT and DPS Act, read with rule 5 of the article 22 of the Constitution of India has been violated in this particular case, ma'am.
লাইন অফ বেশি জাস্ট লাইন রিপোর্ট হয় না একটু রিপোর্ট হলে একটু ক্লিয়ার হয়ে যাবো দিকে এই সাব ক্লাস 3
my lordship. Not only, my lord, in the detention order as well as the rejection memos, my lord. In the affidavit also, my lord, the delay has not been explained. It is my limited prayer.
My lord, the law is very much clear, my lord, but my lord, different opinions come, my lord, because of the interpretation of the law, my lord. My lord, clause 5 of the article 22. It specifies that, my lord, a person reasons of the grounds of detention has to be communicated as early as possible, giving reasonable opportunity of file representation. Now that is very specific in the PIT and DPS Act. I am reading for my interpretation, my lord. Again, my lord, clause 3, subclause 3 of the PIT and DPS, my lord. For the purpose of clause 5 of the article 22 of the Constitution, the communication to a person detained in pursuance of a detention order, detained in pursuance of a detention order of the grounds on which the order has been made shall be made as soon as may be after the detention, as may be after the detention. So these 2 points, my lord, detained in pursuance to a detention order and shall be made as soon as may be after the detention, but ordinarily not less than 5 days. Now, my lord, for example, my lord, a person is detained, my lord, may be arrested in a Sunbury PS case, maybe for theft or a case. He's in jail for 45 days. Subsequently, on the 46th day, if that person is to be shown arrest in another case, maybe Dispur PS case. In the second case, on the 16th day, it will be his total detention is 61 days. Now, if the person go to the court and seek bail, that I should go default bail because I am 60 days, more than 60 days. So he is seeking bail in the second case. So in second case, he is shown arrest on the 46 days. That means till that day only 15 days. So that is has to be counted from that order, on which order or for what case he is seeking. Now, yes, this person was granted bail in a particular case. After about 3 months, he was again arrested for a similar act of offense, my lord, commercial quantity. Now, the order was issued, detention order was issued on 14/5. It is at Delhi. Now communicated to the state government, to the jailer, and jailer executed in presence of the NCB authority, his signature NCB authority, executed it on 24/5. My lord, kindly come to page 71, my affidavit, my lord. So, in pursuance of the detention order, my lord, he was in jail in connection with a police case, not in pursuance of this order. He is in jail in the second case. So, in pursuance of this order,
My lord, has any other court interpreted is in this manner?
my lord, in one case, but I forgot, my lord, the Garden Chief Justice, my lord, I have appeared, my lord, there was a delay, but that delay was made in execution. There are 33 or 31 days delay on execution after passing that order to execution. So ultimately communicated on the same day. So that was counted, but that court said, no, it was executed. But right now, my lord, I'm not that. But if we go by the statute only, my lord, by this clause, after being, as soon as maybe after the detention. So, my lord, kindly come to page 71. This is the detention order. Here, my lord, in Hindi, I have the translated copy also, my lord. I am reading in the Hindi version of the Detinu Malar. मुझे यह दस्तावेज पढ़कर समझाया गया और उसके बाद ही मैंने हस्ताक्षर किया. Pramod Yadav, 24/5/24, signature attested by the assistant jailer. Now in Malad NCB authority also Malad in the right hand column Malad. My Malad type copy is in page 70 Malad. The detention order has been served Pramod Yadav in presence of jail authority. The order was read over to the Pramod Yadav in Hindi and explain him in Hindi. His rights to file representation, if he so desire, has also been explained to him. That is itself on the date of execution, that is 24/5. Now, my lord, whole grounds and the other related documents in translated form was supplied on 28. That is in our affidavit. That is also within 4 days. As per the clause 3, not below, not later than 5 days. So when it is executed, on the same day, he has been explained and he put his signature, the Detinu Malab, and the whole set with Hindi translated copy was supplied on 28. So, my lord, this clause is very much specific. Detained in pursuance of the detention order. Detained in pursuance of no other case, nor in pursuance of the detention order. So, in pursuance of the detention order means this order, my lord, detention order 14. So, he is in jail. He was in jail regarding other case, my lord. So, that police case. So, it is executed on 24th, on the 24/5, that is on the 10th day, and same day, my lord, he was explained in Hindi, but Hindi translated copy was supplied, that is in our affidavit. No documents was there, but supplied on 28. Not to my understanding, my interpretation goes, my lord, this clause is very specific, and he submitted representation. He is saying our delay. Now, my lord, 14/5 he has been explained. Okay, 14/5. Then 28/5 whole document is in Hindi supplied to him. Kindly note that date, my lord, 28/5. Now, when he filed the representation on 13/6, that is 15 days delay. My learned phrase stated that there is a delay of 8 days in rejecting the representation, first representation by the detaining authority.
If I may clarify, my lord, I calculated it from the, my lord.
28/5 supplied, and he made the representation on 13/6. That is 16 days, my lord. May is 31st month. So after 16 days, he has made the representation. Now representation through jailer, it would go to the authority, and in between 8 days, there is a Saturday, Sunday. First, that authority has rejected on 21/6, 21/6/24, page 72. So, his first reply to the representation by the detaining authority, by the authority, concerned authority on the 8th day. In between Saturday, Sunday is also there. Now, the second stage, my lord, before confirmation, my lord, there is a procedure to take the consultation with the State Advisory Committee. In between, that was taken. After the confirmation of the State Advisory Committee, my lord, kindly come to the page 75. This is the confirmation order by the government. Confirm on 16/7/24. Last para, if I read, my lord, page 75. Now, therefore, in exercise of the power so and so, 9 of the so and so, the central government hereby confirms the aforesaid detention order. So this is confirmation on 16/7. Thereafter, only on 18/7. After 2 days, the government, after confirmation, government finally reject his representation. first, within that 8 days, the authority, my lord, 21(6). Then there is a process for consultation with the state government, state advisory authority, my lord. When opinion was given, state advisory authority, then on 16/7, authority has confirmed it. After confirmation within 2 days, on 18/7, page 74, that finally the authority has rejected. Now, my lord, where is the delay? My lord? My lord, page 75, my lord. My affidavit, last page. 16/7, last para is the confirmation, my lord. It has to be annexed with annexus C, my lord. But and after 2 days, so my lord, basically there is no delay for my lord, only 3 points. My friend has cited these judgments. My lord, first of all, first ground is, and most important ground is delay in supplying the detention order and the grounds. As per my affidavit, on the same day when it is executed, on the same day he has been explained and he himself put his signature in Hindi, my lord. समझाया गया है, उसके बाद ही मैंने हस्ताक्षर किया है. So he has been assigned, and after 4 days, that is also within 15 days. And if we count from the date of execution, within 4 days. So it is very much within the law. The clause 3 of the section 3, subclause 3 is very much clear that we not later than 5 days. So not later than 5 days. Within the 4 days, we have supplied it. So there is no delay. And within 8 days, he took 16 days to file a representation. That is not argued by my friend that where is his delay? Yes. And
Not relevant. He could have filed a representation even at the end of
Yes.
11 months.
and within 8 days, the authority rejected. Subsequently, it was sent to the state advisory board. After the confirmation of the state advisory board, finally the government has confirmed on 16/7. Within 2 days, 18/7, confirmed by the authority. So basically, my lord, there is no delay. All has been done in accordance with law. He has been given the reasonable opportunity of submit representation. All has been done in accordance with law, my lord. And I am emphasizing on only these 2 points, my lord. Subclause 3,
Just
detain in pursuance of the detention order.
we'll take a break and come back. By the time you just take instructions, you look at this page 37.
My lord.
In page 37, this representation is to 4 persons: Joint Secretary, Secretary of the Government of India, Chairman Advisory Board, and Deputy Secretary,
Yes,
Government of
sir.
India.
Yes, sir.
Now, this disposal of this representation must only be by the detaining authority and the government, or all 4 are required to address it. Just find out that,
Yes, ma'am. I'll telephonically take it.
because whether it is required that only 2 can do it and others are not required to respond. Mr. Sharma, try to contact this advisory board. So, somebody in the home, they will be able to tell you that whether the advisory board is also required under law to dispose of that representation.
They have disposed, madam.
Huh?
Advisory board disposed.
They have disposed
They
it.
have
Where is that?
That is in my petition, I have annexed.
Okay. Okay, it is disposed of. Okay, then
Yes.
state advisory board.
Already disposed.
Okay.
That is why, my lord, this order was passed on 16/7.
Submission. Which page is that?
My lord, page 54, some more petition.
No, 54 no.
54 mention আছে নহয়? Decided to summon 54.
Because I don't have a recollection of that statement. That's why.
Central 54, my lord, fourth para. Central government considered the opinion of state advisory board. as-
Consider the
No, that is,
Opinion.
but
that is
regarding
opinion. I am on the disposal of representation.
Disposal of representation. My
Whether
lord.
it is required or not, because that submission, I did
Yes.
not,
Yes, my lord.
I don't have recollection of that submission. So that-
My lord.
My lord.
Take a break and come back.
I have
You
gone
see,
through the evidence, Lordship. I have
Huh?
gone through the evidence, Lordship.
Yes.
And Lordship, although evidence part is clear, Lordship, but there is some lapses regarding Lordship document, Lordship, to place a
you see,
relationship with the.
first deficiency is, in the case of the petitioner,
Yes.
is that the name of the father changes, correct?
Yes.
But the change you will find is Asiruddin Sarkar and Asiruddin.
Yes, Lordship.
So it's a minor spelling mistake.
Yes, Lordship, that can be accepted, Lordship. But Lordship, proceed, Lordship, namely, Lordship, Jahanara Bibi.
Huh.
She is the daughter of Lordship Abdul Jalil.
Huh.
And so to prove that one only, there must be some document which establish her link with her projected father, that is Abdul Jalil Lordship. But there are no such document, Lordship, only Gao Panchat certificate and Kabinnama. Kabinnama, Lordship, has already been observed, Lordship. It was Lordship, after 5 months of marriage, it was registered, and that register was prepared in the year of 2017, Lordship. And Lordship and GP certificate, Lordship, only on the
Okay,
basis of application,
if
Lordship.
you have some answers, we first hear Mr. Ali, then we'll come back to you.
Yes, my lord.
Lordship.
It's a preliminary,
Regarding my lord,
next,
regarding the GP certificate, my lord, GP certificate, and he also the secretary on secretary
Yes.
authority also my deposit honorable courts, my lord. As the company, my lord. As DW, my lord, 6, my lord.
just a moment, Mr. Ali.
DW 6. Is coming this number, my lord, is 66.
Page 66.
Yes.
Yes.
And my lord, here the Kopaman Khatian, the test collector, he also the bench assistant deposed as a DW3, my lord, that is case 55. Case 55. DW3.
Yes.
And the traditional grandfather land and with the reports, my lord, 1963, 1961 in Khatian, my lord, and that document in report, my lord, that Khatian and government report also, my lord, Khatian number 52, that number 107, 11, this is the name of applicant, technical grandfather of the traditional, my lord. And next, my lord, beside this, the Kazi have no registered to use, but he clearly stated that the petitioner is the daughter of the
No, but you see, there's a defect here. When I'm asking questions to you, questions will slightly change. Please come to page 55, which you are referring to. Is the question of the tribunal.
Yes, Lordship. Not
In
crossing the
exhibit J, the number 1077 is seen, but in the original Khatyan, there is a letter D before 1077, which is not in exhibit J. Therefore, the copy is not a true copy.
Also, Lordship,
my lord.
Lordship. Huh?
The record, my lord. The exhibit C on record, my lord. The Khatyan part, my lord.
Yes. Therefore, if it is not a correct copy of the original,
Original
where is the
Khatyan-
document?
original
Which
Khatyan
page is the
record, my
document?
lord.
Huh?
In record, my lord. I have-
Okay, just pass that record.
I have been record. Certify কবি।
Khatyan is by DW3, right?
Yes, my lord.
Okay.
This is exhibit
My lord, J, my lord. J,
K,
J, my lord. J.
J.
However, my lord,
No, just we are not yet over with that document.
My lord, this is showed that the petitioner's grandfather name recorded a land holding certificate, my lord,
So the query is what happens to the document when it is not tallying with the original? Is it, will it remain believable? That is the query.
My lord, they should the official authority, they are also the main authority person, my lord. The authority, they declare, they're authorized. Official person also when
We have,
no, my lord.
oh, it's very difficult if you start arguing without looking at the records.
Without permission of the court, man, so
No, in my court, I don't think anybody wants to requires a formal permission. But my court master, if you ask him for a file, in his presence, you can look at it. You just can't take out the file. You are not permitted to take a photograph of the document on record. Except for that, if you want to inspect the records, I have a standing instructions. At least in respect of my code, I can where I am there as a bench member. No. When I am in the bench, in none of the cases I have. Remember, I have stopped anyone from looking at the records. But if you look at if you start arguing without looking at the records, then you are facing two people who know how to read the records. Now you see the difficulty is in these cases.
was,
I will tell you, will show you what has happened. Do you have the original one? No. Original document do you have? No. You don't have that.
that document I have.
Okay. Okay, please continue.
That part of the document, my lord, then some time maybe allow me, my lord. Next I will go through the report and I also contact with my client.
So go through it because it is very technical.
Oh, sir.
Yes.
Even Lordship Latmondal also don't know how entries were recorded from 10 to 17 entries were recorded in the Khotian Lordship. Even Lordship Latmondal also don't know Lordship how entries were recorded. 10 to 17 entries were recorded. Lordship. That was page 64 Lordship.
64.
For question put by the tribunal. Second parallel.
64 questions by tribunal. In exhibit K, there is no any seal as identity. Who copied who?
No. I cannot say how the 10 to 17 person's name has been
You're
recorded.
reading page 64.
Yes, Lordship.
First line is the certificate copy. Second
yes.
paragraph is exhibit L.
Yes. Then question put by the tribunal.
Question put by tribunal. In exhibit K,
Okay. There is no any seal
seal
and
has
as identity.
who copied or who compared.
Who compared.
Correct.
Yes.
Have you ever
So-
seen the certificate copy of our court? Comparing assistant seal is never identification. His identification is never there.
Next line, Lordship. I'm coming. I'm saying about next line. Lordship.
Yes. From the record, I cannot say how the 7 to 10 to 17 persons' name has been recorded, including Abdul Jalil in the draft Jamabandi. The draft Jamabandi was corrected on 3/3/2000. Which is that exhibit? Exhibit K.
Yeah, my lord.
Let us see that. You see, subject to corrections, we have come across the word draft chitta,
Yes,
correct? Because chitta is only in a draft,
yes.
but to have a draft Jamabandi is unknown to me, at least. But this is how your officers are functioning. The officer says that it's a draft Jamabandi. Now, you look at now look at this provision. Section 41 to 41,
Entries in record and their effect.
41(2).
Every entry in the record of rights made under this section shall, until the contrary is proved, be presumed to be correct.
$25 I have spent there. And therefore, this witness, you see, look, you come to page, the document is not there. The document is पट्टा इटू पट्टा वाले पे जमा दिया होगा चित्र पहले भाग गया था एक बार हाँ मुझे ऐसे चले गए दफा फिर हाँ देखा भाग गया चित्र को नहीं समझ That's why it's very difficult unless you see, Mr. Sharma, you see, the difficulty is that many provisions I may not be able to immediately refer to and cite, correct? Because now we don't have the occasion to look, read into this land revenue regulation and all to memorize it right now. But you see, the fact is that what you call, we have some experience in looking at the records. That's why we are showing it to you. So you see the Jamabandi, I flagged it. Yes, that orange flag.
But
Yes, Jamabandi. Yes, correct.
okay.
Now this is the Jamabandi. You see the first remark column and second remark column. It says about an entry.
Hmm.
So if a person from a lot bundle office comes and says that I don't know how it has happened,
Yes, Lord.
that means he has only one interest.
Hmm.
Correct.
Hmm.
And you see the difficulty to exhibit a document. You see the first question you should have asked at that point of time. Here the inadvertently the government advocate is not there.
Yes. Yes.
So the question is a positive question, saying that please tell us how this name is entered. He said I don't know, but there is no next question to doubt the credibility of the entries. There could have been a better question to doubt this. And what happens is that if you don't know how to cross-examine in the matters like this, then lies the difficulty. Because a remark, to understand a remark, you will always require the order of the circle officer where he has passed the order. So that neither these tribunals are trained, nor you take the trouble of cross-examining him. If you don't know what is the right question to be asked at this moment. Because in the record of right, it's shown you 41.
Yes.
The entries are made, it presumed to be correct.
Yes.
That presumption is there. So therefore, how the entries are made there, you must have a general knowledge of how things are happening.
Yes, Lord.
And every order you will find, there's a remark said,
Yes.
pursuant to order dated so and so,
Yes,
এই তারিখৰ ইমান গোচৰৰ হুকুমতে নামজাৰি কৰা হ'ল.
হয়.
Unless you look at the order, you will not know what is happening.
Yes, yes.
And if you're not trained well
Yes.
in these matters, you will not know how to cross-examine.
Lord.
And then there's a presumption to overcome that presumption, you'll have to doubt this document, create a doubt in your cross-examination.
Yes.
There lies the difficulty. And we stop it there. Even if you forget all the documents, let us presume that all the documents are there and it favors you, but still there is a disconnect.
Yes.
You have not been able to show that the man who deposed as DW2 is your father, except for an oral statement. An oral statement is something we have so many orders why an oral evidence cannot be relied to prove parentage. Because there is another way of looking at it. This petitioner, her name is not entered in any of the land records.
Yes.
Therefore, whether she is a part of the family, we don't know. There's no document at all. If this Gram Panchayat certificate and this what you call Kabinnama goes.
So GP also
depose the courts, my lord.
Hmm?
The অপঞ্চায়েত authority মানে এই পঞ্চায়েত
But that document goes. The document, if it goes, then how would you sustain its entry? I'm posing you a different question, reframing it. I posed a different question to Mr. Sharma. If a document itself is inadmissible in evidence, because the judgment of this court says the document is inadmissible in evidence. One, it is inadmissible. You will have to demonstrate how the entries therein can be.
the voter is naming Indian voter list and first time 2005 naming Indian voter list with D1 with the
Correct.
D. So prior to the with marriage, my lord, he was not eligible to voting right with his parents. So there are no voter list. And secondly, my lord, the petitioner is related person is not going to teach school. So that part also. And the land, my lord, you have to know, there is no record. But the mainly, my lord, father when deposed, my lord, with the all these parents, children, my lord, my father, my daughter, parents, father, parents, grandfather, all family members, my lord.
No,
And
Mr. Ali,
all the
Mr. Ali, you see, the question is, we are not saying that the statement is false. But even if this statement is true, then also there are authorities on the point which says that oral evidence with regard to parentage is inadmissible. So you'll have to demonstrate that that divorce that judgment. We can still read into this oral evidence to establish that the proceeding is the daughter of DW2. That's one. Second is that if this Kabinama fails, as has been done in this case, because the witness comes and says that it is his register. Once he says that, therefore the presumption that it is made in course of an official discharge of official duty, 114G goes, and therefore 115E, 114E, that all judicial and official acts are duly performed. That goes away. You look at 115E, 14E of the Evidence Act, that goes away. So if it is not a judicial or the other act, then you show it's done in due process of law. Because he admits that that the marriage register is by him, created by him in the year 2017, and the document is pasted there without being written. So if it is not an official document, then the document cannot be said to have been proved, even if it is a copy. Because the copy is not of a register maintained in which can be said to be a public record.
my lord, GP certificate.
Hmm?
The link is only the GP certificate.
We take it, we give you some time to make more preparation.
GP.
These are the only two questions. You prepare and argue on the next date. Both sides are represented on the prayer made by Mr. H. Adil and counsel for the petitioner. The matter stands adjourned today. List in the month of January 2025 on a date to be fixed by the registry. Go through the records, otherwise we don't find you have a case. You see, we are giving a hint. We are adjourning it for a reason, but there is, if you read the document, there is something which you can reply. We don't know whether we will accept that reply or not, but there is something in the document which you can possibly argue. We don't know whether it will be sustained or not, but you'll have to go through the records.
No.
We may not be able to tell you what.
Upgraded item 16 for hearing.
Yes. This is not a foreigner's tender. The tender is not related to foreigners.
Actually, it was specially allotted to the prudential also because cannot take up the matter.
Huh?
The judge who is sitting with honorable chief justice cannot take up the matter. Lordship.
Okay,
That's why
okay.
it's allowed.
Okay.
Basically, Lordship, I challenged the cancellation order, Lordship, where my contract was terminated, Lordship.
Yes.
Lordship, if I may start with the contract agreement, Lordship.
What has happened to the work? There's a stay now for the work.
Lordship, there's no stay. Actually, we have filed this appeal on a very limited ground, Lordship. Otherwise, there are apparent anomalies that have occurred while issuing the another tender. And the honorable learned single judge have taken into account all those aspects. However, my termination was not been interfered with. That's why, Lordship, I have come before appeal against on very limited ground, Lordship. That now I am praying that, Lordship, why my termination should have been interfered, Lordship.
No, because somewhere I found in this case that post your cancellation of tender, there is also a tender floated for the balance work. So what is the status of that? We did not find here.
Exactly, Lordship, because there is no tender was issued actually, Lordship. It was just.
That's why you are trying to project there. So it was a fake document.
Exactly. It was a fake tender, Lordship. It was fake tender. Even today in Assam PMGSI tenders website, Lordship, if types the tender ID of the balance work, it doesn't appear in anything. It doesn't exist in the official page or in the DIP or office, Lordship.
Okay, who's appearing for this authority? This
Lordship, actually, Lordship, the earlier erstwhile executive engineer.
PWD, who's appearing for PWD?
Pankar, I've informed him, Lordship. He had somewhere actually he informed me, Lordship.
I have informed Mr.
He is coming.
He will come within 10 minutes.
Okay. Mr. Chaudhary, you are appearing for the private respondent? Do you dispute that statement made in the bar that the balance work tender is only a fake? Work
There is
is
an inquiry,
completed.
there is an inquiry report that itself will show that work is also completed. In fact, my lord, what has happened, if your lordship sees the prayer made in the writ petition, the challenge is twofold. The first challenge is towards his termination. And the second challenge is allotment of the work to my client. Now, the question that arose before the learned single judge was, if his termination is upheld by this honorable court, essentially it becomes a PI. Can it be maintained? But still, since certain allegations were made, the learned single judge has directed that certain things to be, certain actions to be taken by the authorities. Now the question is, first he has to satisfy your lordship that his termination was bad. Without crossing the first hurdle, and he cannot even move to the second hurdle because he will lose the locus. If his termination is upheld by this honorable court, what is his locus to even question my allot?
I was just telling my sister that when you are appearing, there's a presumption that the work is completed. Otherwise,
Work was completed, my lord, when the matter was.
otherwise may not be you. Some other would have appeared, but once you are appearing, there's a presumption that work is completed. Payment is released.
Payment is not released. That is because of certain developments. That
Then how can you be present?
there are times when.
Okay.
Lordship, if I may.
No.
Lordship,
Mr. Das, I have not read the brief. Some what you call looking here and there, few ideas and then.
in that case, Lordship, it's like directly come down to the.
No, please tell you because my sister does not know about anything. You have to present as you present because I have just looked into few documents and I have jumped to one or two conclusions.
But I would just like.
Okay, you can come down to the main point.
Exactly, Lordship. Lordship, in that case, Lordship, with the additional affidavit that we have filed on 29/7/2024, Lordship.
It will be in serial page number.
Lordship, it will be page number, it will start from page number 664. Very
Six.
sorry, Lordship, it has become bulky.
No, it's okay. 654.
Starts from 654, 664,
354.
664.
6654. 664.
It starts from
664.
664.
Yes.
Separate additional.
664.
Yes, Lordship.
This
Come-
contains that inquiry report
Exactly,
Mr.
Lordship.
Chaudhary was referring to.
682, Your Lordship.
682.
May I read, Your Lordship?
Just a moment. I'll just record the. Who's appearing for respondent number? I have not seen the cost title. Who's for 1, 2, 3, 4?
Lordship, 1, 2, 3 will be.
1, 2, 3 is PWD.
1, 2, 3 is 1, 2, 3, 4 is PWD, Lordship.
1, 2, 3, 4 PWD.
This one, 5. My learned friends, yes.
Will be appearing? Or
I am for the executive engineer, Lordship. Respondent number 5.
No, 1, 2, 3, 4 will be appearing.
DNAC, Lordship.
DNAC.
DNAC.
But one thing I must point out, I don't know whether this copy was at all served on us because my records show that this affidavit is not available.
No, may not be, may not have been given to you. Additional affidavit by the appellant.
It was filed on 29/7/2024.
I appear for respondent number 6.
Some Sudesh Gautam has received it. For you? No. K. Sinha has received it.
I am being assisted by Mr. J.M. Chaudhary.
I am an ABT for
You and ABT Hawk. Okay, there's a signature of one Sudesh Gautam. It's not associated with you. Then you have to give him a copy.
Sure. Holding only single.
Copy is only given to SCPWD. Just see this. I don't know the signatures and all. Just check it out.
Otherwise, this affidavit is very important, Lordship.
It's okay. Just let him check. No, not yours. Because then I save my winter vacation.
Exactly.
And it is a pretty, as I find, my lord, it's a pretty bulky affidavit.
No,
We might have to respond to it also.
No, you see, what happens is that with these two questions we asked, we are narrowing down the issues. If you have already done the work, then this matter is infructuous.
Yeah.
It doesn't take us much time, except for the time you take in hearing. And the second part is of termination. If you have done the work, then compensation would be the only
Absolutely.
revenue. So it will not take much time. The volume does not deter us.
True.
I just wanted to pick a few points to make myself smile and then. Let me try John it.
I understand. Very sorry.
We are not fixing a date. You please make a mention because post
understand.
reopening, again, there is a vacation during, so please make a mention.
Otherwise, my humble submission is this work is only 65% completed upon the recent inquiry, Lordship. Only 65% work is completed. There are documents done by Lordship, the Chief Engineer.
No, but you see, we can then narrow down. No, Ms. Das, you can narrow down. You see, number one, even if some work has started by Mr. Chaudhary, in that event, we can't stop it. Because it's a PMGSY road and of 2019, right?
2019 contract.
2019. So at this stage in 2024 to stop it would not be in public interest. And for that will be guided by the principles of 21A of the Specific Relief Act, read with recent judgments of the Supreme Court, where it says that in ongoing projects, it should not be, stay should not be granted mechanically, this one. So if some part of the work is done, then notwithstanding that you may have an arguable point, but we have expressed our mind, this is the only relief you can.
Exactly, Lordship. Whereas that is the mind, Lordship, taken by the learned single judge while disposing this matter, Lordship. Lordship, but our case was a bit different, Lordship, because the work was never completed, Lordship. It is still nothing has been done, Lordship, after that 65%. That is our.
No, but you see, But you see, Mr. Das, that's why I said you may have an arguable point. That is one part of it. But you see, the second part is that the second tender was acted upon. Once that is acted upon, then to have a stay will be really difficult. Even if it is some percent of work is done. Now, if that work is incomplete, it will for the respondent authorities to take a call as to whether they would like to continue with Mr. Chaudhary.
Exactly, Lord.
Correct.
But it is their submission that work has been completed.
But then the scope of interference is diminishing. So even if we adjourn the matter, doesn't make much of a difference.
Let it be adjourned for the day. Your Lordship. I'll serve them a copy by tomorrow, Your Lordship.
Mr. D.G. Das, counsel for the petition. Mr. D.G. Das, counsel for the petitioner. Mr. D. Nath, senior government advocate, appearing for respondent numbers 1 to 4. Mr. A.T. Sarkar, Law counsel for respondent number 5. Mr. I. Chaudhary, senior counsel, assisted by Mr. J.M.A. Chaudhary, counsel for respondent number 6, are present. Next para, the learned senior counsel for the respondent number 6 has pointed out that a copy of the additional affidavit filed by the petitioner is not served on his instructing counsel. Accordingly, matter stands adjourned today. That the additional copy of the additional affidavit filed by the petitioner be served on the learned instructing counsel for the respondent number 6 within 2 days. Next, this is the matter. Matter stands adjourned today. Next, this is the matter. In the month of January 2025 on a date to be fixed by the registry. Liberty granted to the petitioner to make a mention. Petitioner's counsel, learned counsel to make a mention.
Right.
When you make a mention, just inform them about the date, their convenience. No, it's not, it's okay. But tell Mr. Chaudhary also for the convenient date when you want to make a mention, take it up.
Item 7.
I was just here some time ago. Okay. We'll see after some time.
Item 8.
Lordship, 8 and 9 Miller. Which are being taken up after vacation Miller with a concept of the planet penguin.
After vacation.
Yes. Otherwise, I have little ready with.
Hmm?
Nice. I am also ready, Lordship. If he wants to argue, Lordship.
Last one Miller. Not in a mood Miller. Since 10:30 we are waiting. After which.
I don't know.
8 and
Okay, both sides are represented on the player made my counsel for the petitioner, Madison is adjourned today, list in the month of January 2020 on a date to be fixed by the registry.
We need a John 12. Yes, yeah.
Item 12. Hmm? I didn't get it. Please repeat again.
Praying for adjournment, Lordship.
Praying for adjournment. Okay. Anyone is ready with any matter? No one is ready for any matter?